So, speaking of depositions and discovery techniques, they are crucial aspects of trial preparation. How do you utilize these tools to strengthen your cases and increase their value? Are there specific approaches or methods you find particularly effective?
Yeah, so let's start with the word discovery, right, which is the broad term for what the attorneys do to prepare a case. Well, it's very, very important to discover all the evidence in a case. When you start out a case, you know a lot, but you don't know everything. Through discovery, uh, an experienced and a skilled attorney wants to know all the facts, both good and bad. Right? You don't want to just bury your head in the sand and only want to hear the good news. You want to find out all the bad news so that you can be properly prepared to deal with the bad facts in the case or the challenging issues. So that's very important so that as my client's advocate and trusted counsel, I can give the client clear-eyed advice on what to do with a particular case. That being said, I view every step in the discovery process, especially depositions, as an opportunity to increase that leverage, to put more and more credit in my stack, to create more facts and evidence and emotional touch points that I know are going to accrue to my client's favor. And just as I'm factoring that into what my expectations will be at a successful trial, I know that the other side, experienced defense counsel and insurance adjusters, will take those same facts and factor that in. And this is just a long process and a never-ending one. Every deposition, I seek to improve our position. So if a deponent, maybe it's a defendant or an employee of the defendant, if they say something that's good for us, I leave it. It's gold. We've got a transcript of deposition testimony under penalty of perjury. I've got that. I store that away. If they say something that is unreasonable, that's contrary to the evidence, it just doesn't make sense, they're being defensive, they're being combative, I just work that. We just go on and on, back and forth, because I know that if a witness for the defense conducts themselves like that in front of a jury, that's all going to accrue to our favor. Because jurors don't like people who are defensive and unreasonable and take combative positions that aren't supported by the evidence. I let that play out because I want the other side to see, hey, look, this witness that's important for them, they're not going to do so great at trial. So I want to put that on full display. And once again, got the deposition transcript. If they decide to try to clean things up, I'll have the deposition transcript to show how they had previously answered a question that now they try to be more reasonable about. So every time I conduct a deposition, my goal is to improve the strength of our case. So the more depositions, typically in my practice,